Yes.
So, my lord, you were asking, just before we adjourned, what is the effect if the court is with me on our first argument? And we accept, of course, that even if there is not a mandatory, if the mandatory wording is not clear enough, that under, this is in the core bundle, tab 10, page 166, there is the discretion to exclude if you submit a non-compliant bid. But at the same time, of course, allied to that, you have the ability to waive requirements and to clarify.
Yeah.
Now, we say the practical impact, though, if the court is with me on ground one, is that the exercise of discretion really falls away because it was parasitic on there being the clear mandatory rule under 2.2. And we can see that if we go to the decision, core bundle, tab 5, page 88, paragraph 149.
Yeah.
Could I ask your lordships to read the defendant's letter?
Yeah. I'd be grateful if somebody could give me a reference, not now, but a reference in the bundle to this letter. It's referred to repeatedly in the judgment, but I couldn't find it in the bundle. There are other letters of June, but not the one of the 22nd.
We may need to hand that up then tomorrow, my lord.
Yep.
So we say that if one looks at this, there is no, although it ends with there's a separate right to disqualify non-compliant bids under clause 9.2, really the core of this is that the procurement document set out very clearly, and this is the previous sentence, that pricing above the framework prices was not permitted, and there was no discretion around disqualification if that requirement was breached. Now, if that's wrong, and that wasn't made clear, then that really vitiates everything else, because the rest of the suggestion that it would be unfair to the compliant bid or a breach of transparency to do anything other than exclude is predicated upon an assumption that there is a mandatory, a rule which is stated to apply without exception of disqualification. And one of the problems in this case that we identified was that there weren't disclosed any contemporaneous documents which weren't extensively redacted for privilege. But what we did have was, after the event, witness evidence. And indeed, that simply confirms this. If we go to the supplementary bundle 2, and go to the first witness statement of Samuel Birch behind tab 17. Page 195.
Yeah.
See, he said they considered two options. Paragraph 37 on page 195.
Yeah.
The first was to request resubmissions. We were concerned that by doing so, we'd be giving an unfair advantage to these two bidders, as we'd be giving them an opportunity to resubmit their bids when we'd already received a fully compliant bid from another bidder. We needed to keep the procurement process fair and equal between bidders. We consider that if we'd given the two non-compliant bidders the opportunity to amend their bids, other suppliers could argue they should be given the opportunity to amend their bids as well. And then two, the second option was to discount the bid. And then they considered that. And then if we go to 3, we see this is why they decided not to do any clarification or discounting, because they've said we can't.
Yes.
And that's why, I mean, the very short point we make in relation to all the rest of my grounds is that they misdirected themselves. They proceed on the basis they could not do anything other than exclude, and a fundamental pillar of that was their reliance on their understanding that there was a clear mandatory rule of exclusion.
Yeah.
So I propose to take the rest of my grounds relatively swiftly.
And that's if you win.
Yes.
You say that has a major effect on ground one. I mean, that has a major effect on the rest.
All the other
I understand
grounds.
that. And if you lose,
we then say, even if we're wrong that there was, if there was a mandatory rule, then one still needs to consider the explicit power to waive or to clarify. And I'll come on to why we say Tideland and Antwerp, the principles set out there, are relevant.
okay.
Because we know that there is, because of proportionality, even where the rule is crystal clear, it is still circumstance in which it's obligatory to exercise power to permit correction or clarification. My Lord, does that address that your question?
Yes, it does. It's quite important if you
Yes.
have an issue for the court to know what the consequences are, depending on the result. But anyway, so that's it on that point. So now we're moving on to.
So there are really, I can cluster these under 2 points. One is the judge was wrong to find that it would have been unlawful to do anything other than exclude. That was DWP's case. It would have been unlawful. The judge agreed with that. And then we go on to say that the judge was wrong to find in all the circumstances clarifying or correcting wasn't required. We say in the circumstances that was, I'm going to put it either that was an obligation under Tideland and Antwerp, or really there is no rational basis to do anything other than that.
So the first is wrong to find that it was unlawful to seek clarification.
Yes, that the discretion could not even be exercised.
Yeah.
And the third is that in the circumstances here, there is no lawful justification for excluding. And one can put that either that there is an obligation because of proportionality, or when one strips away all the wrong reasons, nothing's left to justify exclusion.
Yeah. Okay, understand that. When you say wrong reasons, you strip aside the wrong reasons for saying no power to, or no that they couldn't seek clarification.
Or the justifications for the action they took.
Yeah. Yeah. Okay.
So on would it be lawful to clarify? You had my submission this morning that one applies the arcuous conditions. Those are the conditions. Was there an obvious error or ambiguity? Would it have effectively led to a new tender? And would it have given rise to an advantage to the winning bidder or a disadvantage, bearing in mind the outcome of the competition? So on that first, the issue, and this is ground 2, the judge said that there was no obvious mistake. And we can pick this up at paragraph 192 of the decision. That's on page 97.
Mm-hmm.
And in short, the judge found that there was no obvious mistake where the intended price was not within the knowledge of the defendants. And we say that's just a wrong approach to obvious error. it's conflating two different things. Is there an obvious error? And secondly, can the tenderer provide an explanation for that, which doesn't amount to a fundamental change to the bid? And we can see the problems that causes, because if one applied to Siemens, it just would not work. So just focusing purely on that point is there an obvious error? The judge said, no, there isn't, because the intended price was not within the knowledge of the defendants. So that's just wrong. Secondly, you'll see in paragraph 193, I also framed this as not just an obvious error, but there's an ambiguity. Because on the one hand, Optima was accepting, without caveat or qualification, that its prices would be capped. And on the other hand, it had put in some cells which were above the price, the maximum prices. And we say this is analogous to Tideland, where there seemed to be an explicit acceptance of the validity period of the tender and that the date didn't match. And we say the judge, with respect, was wrong to reject that argument. He says, one picks this up halfway through 193, in my judgment that does not lead to an ambiguity, it leads to a conclusion that Optima failed to provide a compliant bid and to make an accurate statement that it was providing a compliant bid. Now that's not the argument. The argument is not simply a self-certification of compliance. The argument was, as in Tideland, Optima had explicitly agreed that the conditions would apply, which included that the framework agreements were maximums.
Yeah.
So that really deals with ground 2, which was an obvious mistake or ambiguity. So we say the first of the conditions in ALCUS applies. Then turn to the next ground, which is that the judge erred by finding that the price could not be clarified because that would lead to a change in the tender unless the defendant, the contracting authority, could independently know or be certain what the intended price was. Now we say there is an air of unreality about this because I've already taken you to a supplementary bundle 262 where the very people who checked could see what had happened, the typographical error or the cut and paste, the wrong mode of delivery had been used. But we say...
Sorry, what was your heading for this?
This is ground 3. And if one looks at ground 3, page 14 of the core bundle has the grounds of appeal. This is erroneously holding that waiving, correcting, or clarifying a pricing error is a breach of principles of transparency and equal treatment where the contracting authority, unless the contracting authority knows what sum was intended. And one can see that. That's a thread through the judgment of paragraphs 192,
Mm-hmm.
195, 196, and 198. And the reason that the judge says that is wrong is he says that would be to change the bid and it would be unfair to the compliant bidder. So just to make a few points on these. First of all, it's quite clear in the legislation there is no requirement for corrected information to be apparent on the face of the tender. You don't get that in Regulation 56. You certainly don't get it in ARCUS. It's not one of the conditions.
That what? That corrected... What
That the intended information must be apparent on the face of the tender. Because his logic, the judge's logic is, if you don't know, if the defendant can't know what was intended, the originally intended price or information could be changed, and that would be a change to the bid. That was the logic.
Mm-hmm.
And we say, but the test is not whether there's a change to the tender, it's whether there's effectively a new tender. Now we say it's far too blunt a rule to say that the provision of a corrected price is unlawful unless it can be seen on the face of the tender. And we've seen from Siemens, one can see huge, high-value contracts with thousands of price components. One might be missing, it might not be apparent on the face of the tender. That does not mean of itself that's an unlawful change, that's the wrong test. Now, of course, there will be cases where it is problematic. And ADEA is an example of that, and that's really the high watermark of the case against Optima. And that was the case, because I haven't gone to that this morning, I'll go to that very briefly, just so I can say why that is not an answer to our case. That's it, behind tab 2.
Mm-hmm.
Can I ask your lordships to read paragraphs 3 and 4 on page 21?
Mm-hmm.
So this is the case where the tender price was determined by the coefficient. So, ADEA, if one actually then looks at paragraph 9, one can look at the evaluation.
Yeah.
So it's in 10th position because it made a mistake, which was relevant to the scoring and which went to the heart of its pricing. It affected the scores. And it argued that it should have been allowed to correct that really fundamental error at the heart of its pricing. And one can see on page 27, paragraph 39, the Commission's argument. If it had corrected the applicant's tender, that would have constituted an infringement of principle of equal treatment. It considers that corrections of clerical errors may be envisaged only insofar as they have no discriminatory effect. So again, not formalistic, the Commission itself. Clearly, the implication corrections of clerical errors may be envisaged where they don't have any discriminatory effect. However, in view of the key importance played by the tender price in assessing the tender, any correction of the applicant's tender or any request made to submit a new tender would have been bound to infringe the principle of non-discrimination. This is not a statement of law that whenever there is an amendment to a tender price, it's bound to infringe the principle of non-discrimination. It's reflecting this case.
Sorry, where did you just read from?
Sorry, 39 on page 27.
30. Sorry. Yeah.
So that can't be elevated into a rule. That's a reflection of that case where the coefficient determined the tender price, which determined where people were ranked. And then paragraph, I'm going to pick this up at paragraph 45.
Yeah.
Where the court considered, was there a duty on the part of the court, of the Commission, to inquire about this error, and said 46, as to that, the court considers it sufficient to observe the systematic calculation error question was not particularly obvious. Whilst the selection committee succeeded in attributing the error to the calculation, it was unable for that to determine on the basis of the tender whether, and it sets out all the different things it could have been. 47, it was unable to ascertain its exact nature or cause. In those circumstances, any contact made by the Commission with the applicant in order to seek out jointly with it the exact nature and cause of the systematic calculation error would have involved a risk that other factors taken into account in order to establish its tender price, in particular those relating to the calculation of the coefficient and encompassing its profit margin, might have been adjusted, and this would have entailed, contrary to the applicant's claims, an infringement of the principle of equal treatment to the detriment of the other tenders, all of whom, in common with the applicant, are under an equal duty to take care in drawing up their tenders. Then the court goes on in paragraph, I'll come back to that in a moment, paragraph 48, just to finish this. You can note that the court further notes the applicant has neither shown or even alleged the Commission contacted other tenderers who are in a comparable situation in order to correct any errors in their tenders or to provide additional information. In that connection, the court observes that it appears from the report that the selection committee used as an assessment criterion the clarity and precision of the tenders and penalised some tenders because they were insufficiently precise about the quality of the service which they undertook to provide. Now we say, superficially, that helps DWP, but we say it can't be elevated. This is my point about an example being elevated into a rule. In that case, what the court said was there would be an obvious problem here if the Commission were to negotiate by finding out, discussing with the applicant what the error was, which would have led a risk to it adjusting the coefficient, which could have enabled it to rise from 10th place to first place. This is a world away from Siemens, as another example, where the price was corrected, but it was immaterial and insignificant. Mm-hmm. Now, this, of course, was followed by Tideland, it was followed by Antwerps, and it was followed by Arcus, which set out the conditions for correction. And this has not been calcified into some condition or restriction. We see in Arcus what the conditions are. And, of course, we say this doesn't apply to this case, where if one looks at the three errors, two weren't evaluated, just like in Siemens, and the third the adjustment could have no possible impact on the outcome.
Also, this isn't a clerical error anyway.
Now, the final point that I wanted to go to on this ground was to just deal briefly with paragraph 195, which is this concept of fairness to the compliant bidder. And this is a point that DWP made repeatedly, and which the judge, we say, erred in accepting, which is that where one has a compliant bid and a non-compliant bid, it is unfair, it's inherently unfair to the compliant bidder. And that would have been a breach of equal treatment. And we say that's far too blunt a rule for three reasons. The first is that whenever clarification is sought or a correction is permitted, the tenderer who submitted the error-free bid could complain, as Siemens did. Whenever one tenderer is free of errors and the other bidder is permitted to correct, it can be said, well, that's unfair. It's really inherent in the power to permit clarifications and corrections. It's not a relevant unfairness, not of itself. Just as the other bidders in Tideland and in Antwerps couldn't say, well, this isn't fair because my bid, I took sufficient care and my bid didn't contain any errors. The second point is that there is no rule in the legislation or case law that correcting or clarifying an error is unfair, where it enables the bid to be accepted as a compliant bid. And you've heard my submissions on that in relation to Tideland, Antwerps and Arcus, which talked about correction of an error which vitiates the tender. And the third point is that elsewhere, the judge seems to draw an analogy, and this is particularly apparent in paragraph 207, with waiver of mandatory terms and the deadline cases. Now we say that's not applicable here for two reasons. One, you've heard my submissions on Leadbitter. There's a conceptual difference between correction of errors and the late submissions. And two, it's really parasitic upon there being a clear mandatory rule which permits of no exception, which is not the case here, not least because quite apart from how you interpret the troublesome clause, the contracting authority had an explicit power to clarify and waive. So for all those reasons, we say that DWP approached its discretion erroneously. It was a fundamental misdirection where it said it would be unlawful to do anything other than exclude Optima. So that brings me then to the fourth ground, which is really challenging.
Just before sorry, what's your fourth ground?
Let me just check how I formulated it. Yes, erroneously finding that waiving, correcting or clarifying the error was not required and the question of triviality or lack of impact does not arise.
Right, okay, so I think this is the right place. Can I just ask you, on the question of what is a new tender,
yes,
for the purposes of this rule, the European cases are very unhelpful on that. It's clear that clarification can lead to changes which don't fall foul of the rule, and you've addressed that. Is it simply a question of fact and degree?
I would submit yes. I really hesitate to suggest that any bright line could be drawn. I think there's a danger inherent in that because I can't possibly anticipate the possible circumstances that could arise under complex procurements. So I would hesitate.
Well, you're right to be cautious because it's this dichotomy between the very general statements of principle and then the particular facts of the cases. Yes. But to the extent that there is a principle, which one understands as a matter of high level principle, you can't have a new tender. So what does where does the line lie? You would say, well, it is a matter of fact and degree.
Absolutely. I mean, one can imagine a situation where a pricing schedule was so riddled with errors that when asking for a corrected version effectively is just a new document. And that's at one end of the spectrum. The other end of the spectrum is the Siemens style, hundreds of prices, two small problems, doesn't really make a big difference. Doesn't make any difference, not significant. And I really hesitate to go further than that because I think there's a risk of coming up with a rule which one doesn't find in the case law, and one understands why the European Court did not go further and try to define what a new tender is. Because that really has to be determined on the facts that are apparent, taking in mind it's a multifactorial assessment, one would say.
Yes, I follow that. The practical consequences, though, are that you have to. There has to be a certain amount of certainty, a certain amount of clarity about all of this, and the cases, I think, are quite clear that a contracting authority does have duties and obligations, but one has to be careful about loading too much onto a contracting authority. Even if this one hasn't covered itself in glory in this particular procurement.
But we would say in this case, the distinguishing feature, and perhaps unusual feature here, is that Optima's maximum prices were known. You've got a schedule which sets out its maximum framework prices. They could be used to resolve the error. Optima had expressly agreed in its tender to be subject to those ceilings. That's not a change to the tender. It's implementing what it had said it would do in the tender, what it intended. And that error could be resolved without any impact on the scoring no discriminatory effect, and two of the errors had no impact on the scoring. One had a minuscule impact on the evaluation, but that didn't affect the scoring at all. There's no disadvantage. So one asks, what's unfair here to the compliant bidder? This is why I say this really is parasitic on the first ground. One might be able to say it's unfair if there were a very clear mandatory exclusion, which PAM were relying on, and it might have conducted itself differently. But here are situations where there's an express power to clarify or correct. There is an express requirement for substantively agreeing to the terms and conditions, where applying the framework cap can make no difference whatsoever to the outcome. What's the unfairness to PAM? Why is that a breach of equal treatment? And we say the only respects in which it could be a breach of equal treatment would have to apply equally in Tideland or Antwerp.
Yeah, okay, thank you very much. So now you're moving on to...
Ground 4. And this is where I'm addressing and appealing against on page 104, paragraph 216.
What's the heading?
Of ground 4?
Yeah, well, it's just, what's the heading of your submissions? Is this triviality?
No, it's that there is not compliant with either rationality or proportionality to exclude Optima.
Okay.
So I've dealt with why it was lawful, and now I'm dealing with why it would actually, it's the other side of it really, why it would be unlawful to disqualify. It was unlawful. And here I'm addressing paragraph 216 on page 104.
Yes.
And this is where the judge below argued that defendants, basically that it was lawful for them to exclude Optima. And if we look at each of the points, I'm going to address them in turn. 1, the tender was clear and transparent for reasons set out above. Well, if you're with me on ground 1, then that falls away.
So the tender, does he mean there the ITT?
I think he must do.
Yeah.
2, there was a danger of infringement of equality of treatment to have allowed Optima to change its bids in circumstances where PAM had made a compliant bid. Now, you'll have just heard my submissions on this. This isn't enough. The same point could be made in Tideland, the same point in Antwerp. And indeed, in circumstances where, at best, we say, the ITT said there was a discretion to exclude, but also a wide-ranging power to waive requirements or to seek clarification, there is no inherent unfairness to PAM, let alone any substantive unfairness. Looking at the outcome, you'll recall in Arcus the question of, was there, having a look at, in light of the outcome, has anyone been unfairly disadvantaged? No.
There's an anterior point, which is seeking clarification doesn't necessarily amount to changing a bid.
Yes. 3, this was not a case where it's obvious what the intended price of Optima was. In particular, it was not obvious that the maximum line price was intended and it could have been lower. But that could be addressed either by clarifying what the price should have been, as in Siemens, or simply capping the prices. If you're concerned about that, just cap the prices. 4, it was not obvious it would be a quick and easily verifiable process to adopt what the true intention of Optima had been. Now, with respect to the judge, I find that quite difficult to follow. That doesn't need to be an inquiry into what Optima's true intention had been, in the same way that there wasn't in Siemens. The other point is a quick process was exactly what the defendants did undertake when they applied the framework caps to Optima's bid and found that there was just a 0.02% difference. 5, there's no such requirement. They say there was a danger, the judge says there was a danger that allowing Optima to change from a non-compliant bid to a compliant bid was in breach of the requirement that a party should not be allowed to change its bid or to act in a manner which made it likely that it would or might change its bid. Well, my short submission there is there's no such requirement. I'm not sure where the judge has got that from. Then 6. This is the sort of slippery slope argument. If a change could be allowed in respect of Optima, then equality of treatment would have required that all the other non-compliant bidder or bidders be allowed also to reconsider their bids in the same manner, and all that PAM be allowed to reconsider their bid in the interest of equality of treatment. Now, I think there are really 2 answers to that. It's right that one must apply the same procedure to everyone in the same position. That's one of the ARCA's conditions. And it's right that in Tideland and in Antwerps, the court said one's only obliged to seek clarification or correction where it is practically possible and easily resolved. So one can imagine cases like Hersey, where there are hundreds of tenders, and a contracting authority might well exercise its discretion rationally to say, this isn't easy or practicable, to go back and search through hundreds of bids. In this case, there was one other bidder. There was one other bidder whose prices were above the framework. There was no evidence whatsoever that there would have been any difficulty in approaching them. Indeed, I took you to the supplementary bundle at page 270, where you saw, alongside applying the framework caps to Optima, they did it to the other non-compliant bidder.
Sorry, that was page?
I believe it was page 270.
Of the supplemental bundle.
Yes, it's Little Roman 3.
And did that, I'm assuming that
I pass on my client's apologies.
I'm assuming that that was that the figures quoted there, both the percentage and the money, had no effect on the evaluation.
No. Optima was always going to be first. The final point on this is that you might recall the same argument was made by the Commission in Tideland. It didn't stop the obligation arising. In Tideland, the Commission said, well, wait, if we have to go back to this bidder and ask about their period of validity, we're going to have to go to other bidders. That did not stop the obligation arising. Now I'm going to make 2 final points. I hope we'll cover the rest of the grounds. The first one is we say the judge erred in the approach to proportionality and the materiality of any correction. And this is paragraph 206 of the judgment, page 101. And he deals with this paragraph 206 when we say it's absolutely fundamental to the obligation here to see that it was a minuscule impact which had it was completely immaterial, it's insignificant and immaterial, And 206, he says, there was also consideration for proportionality, including the extent of the overpricing, and the fact it was minor relative to the size of the bid as a whole. This was taken into account, although the non-compliances might have been greater. The letter of the 29th of June 23 stated that the £600 figure was on the basis that the maximum framework sum had been intended, but that was not the correct sum. There was no way of knowing what the intended offer price would have been between nothing and the maximum line sum. So let's just pause there. The suggestion here is that rather than it being £600 a year, it might have been £800 or £1,000. Because that 600 is the difference between, was the excess over the framework cap. And so what the judge is saying here is accepting DWP's argument, well, one can't really rely on the 600 figure because we don't know that you intended to price at your maximum. You might have priced below that. It's very difficult to understand the relevance of that. Because using the framework cap, it was already the winning bidder. What this is really about is the saving for the contracting authority between the excess over the framework cap and applying the framework cap. Then the next sentence is further, in respect to the two cases where there were no quantities indicated and no pricing exerted, there could in fact be a call-off subsequently, and so that too could be relevant to the impact of the excessive price. And that's relevant to the need to clarify for the purpose of the contract what the price would be capped by the framework. It doesn't say anything about conditions of competition and the impact on competition, or whether this was material to healthy and effective competition. It wasn't, because these weren't evaluated. And we know that's relevant, and I respectfully commend the approach of Mrs. Justice O'Farrell in Siemens, where she took that into account as relevant. And the final point is the slippery slope, which I've just dealt with. So we say the judge erred in the approach to proportionality. I've already mentioned in 207 that paragraph really deals with waiver of mandatory terms said to apply without exception in the deadline cases, which we said can't be transposed here. The final point that I wanted to deal with was the issue of Optima being responsible for the error.
Before you move on to that, can I just ask, you've been stressing the immateriality in this case. And I can understand why you do that, because there are, standing back a moment, two potentially conflicting principles. The one is that you can seek clarification if there's an obvious error. The other is, but you can't change the bid. So materiality answers, well, lets you drive away between those two principles. His Honour Judge Waxman, in one of the legal services cases, put it, I think possibly came up with a slightly different way through, which is to suggest that if there's an obvious error or ambiguity or gap, clarifying it doesn't change the bid because the bid never objectively said anything at all.
Anything other than that?
Yeah, so what do you say to that?
I say that's a clever way of dealing with it, but I'm not sure that would cover, for example, Siemens, where the bid plainly did say something else, and it's changed. So there were two errors there. There were discrepancies or inconsistencies. The successful JV said we didn't mean to put that. So I can understand Mr. Justice Waxman's approach. Let's suppose instead of putting £53.7, one puts £537. It's an obvious, the decimal place has gone in. One can say you're not really changing it. But this is why I emphasise the test isn't change. It's not change. Is there fundamentally a new bid? And that's really important because there'll be lots of corrections of errors or submission material which are literally a change.
I think what he says is objectively it never said anything positive, because objectively takes into account the fact, okay, it states something, but it's such an obvious error, it can't be saying that.
I understand that, and I think I suppose I struggle with it slightly for two reasons. One is that literally it's a construct, isn't it? It's saying even though there's a change, one deems it not to be a change from all the circumstances. The second point is, whilst it captures the category of permitted correction, I don't think it's comprehensive because of the point that I've already made about Siemens, where I think one could potentially say, you are substituting a figure for another figure, which I did not know as the contracting authority. I'm now going to deal very quickly with grounds 5 and 6. I've agreed with my learned friend that I'll aim to sit down at 3 p.m. I'm on course for that, but of course, before I sit down, if your lordships have any questions, then I'd welcome the opportunity to address them.
You come into grounds 5 and 6. Is this the point about, or is ground 5 at any rate the point about it's your fault?
Yes.
You were going to come to fault.
Yes.
So I've got my next heading is fault then, and this is ground 5, and then we'll come to ground 6.
Yeah.
Which I think you may have covered already, although
I agree.
you'll doubtless
I
tell
hope
me
I have.
that I'm wrong. But I think ground 6 is the point about the misdirection in law.
It is, and I'll deal with that now ahead of ground
Okay.
5. The short.
I'll scrub out my heading
Sorry.
and go to misdirection in law, ground 6.
Yes. So our point was, if one looks at the defendant's purported exercise of discretion, it's really predicated on it all being unlawful to do anything other than exclude, which is also predicated on their understanding that it was clear to bidders, sufficiently clear to bidders, that there was a mandatory rule of exclusion if you submitted any price in excess of the frame one. So we said, on that basis, there was no real exercise of discretion or it misdirected itself. And the judge said no, because they considered options. And my short answer to that is they did consider options and they rejected them all because they misdirected themselves. And it's really no more than that. Now, 5, I really put in for completeness because your lordship emphasised in granting permission that there was no appeal against the facts. And I therefore just wanted to record, I just want to emphasise very specifically how this arises. Ground 5 arises because we below said that even if there is a crystal clear mandatory rule of exclusion, we relied on the in-health intelligence line of case law, which says that there will be exceptional circumstances where it's the fault of the defendants and therefore they should not apply the mandatory rule. And that's the principle often comes up in the concept of deadlines. And of course, even if there's a firm and fixed rule, if you as a contracting authority have made it impossible for people to submit in time, then you can't rely on that.
So hang on a minute. So even if there's a mandatory exclusion in exceptional circumstances, if the error is the fault of the contracting authority, they can't.
That's one example of where it would be disproportionate for them to apply the rule.
Yeah, so disproportionate to apply rule. So this is predicated on you losing ground 1.
Exactly.
Yeah.
Now, we didn't appeal against that. The judge said, no, it's your fault. You made the mistake. It's your fault. Now, we don't appeal against that for the specific purpose that we raised it below. But what we do say is that if the judge, insofar as the judge, it's not really clear, suggested that there was fault on the part of Optima, which would justify disqualification here, then we do appeal against that, or we say that would be a wrong approach for 2 reasons. The first is, as a matter of the case law, we've seen that in Tideland and in Antwerps, and indeed one can see in Regulation 56, there is no condition that corrections or clarifications be made only where there's no fault. And indeed, the obligation can arise irrespective of responsibility, and you will recall from Tideland, that was the Commission's argument in Tideland. It's the tenderer's fault. They should have exercised extreme vigilance. And secondly, we say it would be very difficult indeed for DWP, and we don't believe they do say this, and we say it would be irrational for them to say that culpability alone here justifies exclusion. In circumstances where all tenderers repeatedly made the same mistakes, and where DWP itself failed to pick up an error despite quadruple checking. One would say, what exactly are we penalising here? It's not a rational reason when balanced against everything else to take the course of disqualifying, particularly when one bears in mind the Tideland and Antwerps, where one is faced with alternative courses of action, one should take the least onerous. And the reason why I say I don't believe that DWP are relying on that is, could your Lordships just go to tab 12, where there's my replacement skeleton argument. And this addresses really both grounds 5 and 6. Could I ask you to read the second line, the foundation stone of the defendant's exclusion decision, down to the bottom of that extract?
Which paragraph are you on?
This is 59, so it's the top of page 211 in the core bundle, tab 12.
And that's for 5 and 6. Grounds 5
Exactly.
and 6.
Exactly. So, my Lord, those are my submissions. Are there any questions for me before I sit down?
I've asked for a number of things.
Yes.
Did you have the figures?
I did. Would you mind if I check them overnight? Because I don't want to hand anything up without checking it myself.
No, all right. And I want the letter of the, whatever it is, 22nd of June. But again, I can have that for the morning. Those are the two obvious ones, but there may be other ones, but doubtless someone's got a note. But other than that, those are the things I wanted.
No, I just observe on fault, and this is as much for Mr. Sutawala's benefit as yours, that when my Lord Justice Coulson set out and summarised the principles in Hersey and the Lord Chancellor, he listed them, and fault does not appear there at all, which is something that you probably ought to both bear in mind. I'm not in any way suggesting that means anyone is bound in that respect, but I just made that, I hope, as a helpful observation. But I haven't got any questions.
No? No. Thank you very much.
Thank you.
Thank you very much, Miss Valentine Sloan. So, yes, Mr. Sutawala.
My Lords, I'm grateful. If I could begin by making some introductory points to set out the shape of our case, and if I can put forward what I understand my learned friend's case to be, and I simplify, but I think it's helpful. As I understand my learned friend to be arguing, Ms. Sloan is saying that you may have a change to a bid in circumstances post-submission, as long as that change is not a substantial one. That's one aspect of what Ms. Sloan is putting forward. And we say there's no support for that in the authorities at all. The high watermark of that is ARCUS, but ARCUS, we say on proper consideration, given the cases that ARCUS cites and follows, is not in fact saying that. And secondly, and this is a theme that runs throughout Ms. Sloan's appeal, and we say is simply wrong, is the fundamental fallacy running through the appeal, is that when one considers whether to clarify, a contracting authority, whether to clarify or to waive, it is necessary to look at the outcome of the competition. That's an important factor which should be considered when taking a decision whether to clarify or to waive. And we say that that's not right when it comes to this issue of whether clarification or waiver would be consistent with the principle of equal treatment. And that, of course, is the limiting factor to the exercise of the power of clarification or waiver. It has to be consistent with the principle of equal treatment. And that, we say, my lords, is because the principle of equal treatment is not concerned with the outcome of a procurement. And that may seem like a bold proposition when I state it, but we say the clue with respect is in the word treatment. And as I will come on to develop, what procurement law is concerned with is how bidders are treated in the process of a competition. And procurement law is not procurement law is not stating or mandating a particular outcome. And we say, if one approaches it that way, that Mr. Justice Freedman's decision below, contrary to my learned friend submissions, was an orthodox application of procurement law principles, and that in fact what Ms. Sloan is arguing for in this court is a significant extension beyond the existing principles.
Yeah.
Now, much has been said about Optima would have been the winning bidder. This has obviously been a key theme put front and centre in the court below and before this court. And perhaps we can test it this way, my lord, if I give an example of why we say that cannot be the correct approach to deciding whether to ask a clarification or to waive terms in a procurement.
It can't be a correct approach, or can't be a relevant factor, do you mean?
Well, we say the approach is limited by the principle of equal treatment.
Well, I understand that. You've made that point. Yes. I'm just seeking to clarify what your submission is. You say that Optima would have been the winning bidder. You say that's been emphasised.
Yes.
You see, that can't be the correct approach. Approach to what?
We say, sorry, it cannot be a relevant factor.
Right, that's what
I apologise, It can't be a relevant factor in the authority deciding whether it is obligated to clarify or to waive. Because, of course, in this case, my learned friend is impressing upon the court that there was a duty on the Department of Work and Pensions to clarify or to waive in this case. And we say that when looking at the exercise of the power, or if you like, whether the duty arose upon the authority, the authority should not approach the matter by looking at the outcome of the competition. That's not the right way when considering whether it has a duty to clarify or to waive. We say that's the wrong end of the telescope, if you like, when looking at clarification or waiver. And the reason for that is both, if you like, mandated by legal principle, but also by general principle, if I can put it that way. The legal principle is that equal treatment, and I'll come on to develop this, my lord, is not concerned with the outcome, but more the process. But secondly, as a matter of general principle, we say that authorities cannot know how an exclusion criteria would affect bidders' behaviour or strategy, and therefore looking at the outcome in order to decide whether an authority should clarify or waive, as a matter of principle, cannot be the correct approach. And I give this example to test it, my lord. Suppose you have bidders A and B, and this is a contract to supply, for example, very large widgets. And bidders are required to supply a detailed pricing schedule explaining the price of every part of that very large widget. A rule of the competition says if you do not provide a price for every part of the very large widget... I think
if you... Is this in your skeleton?
My lord, no.
No, I can't make a note of a hypothetical example in a case where there are 3 volumes of authorities. If you've got a hypothetical example that you want to rely on, you'll need to set it out in writing and provide it in the morning, because it's not fair on the court to note down every nuance of a hypothetical example that you say is important if it's not in your skeleton argument.
Of course, my lord, and we'll seek to do that.
Okay.
Could I just skip forward then in terms of this hypothetical example?
Yeah.
If one bidder bids the higher price and the other bidder bids a lower price, and the one with the lower price is missing an aspect of its pricing, and the contracting authority doesn't know what should have been inserted for that particular item into the pricing schedule, has no idea, but can see that it's missing, and it clarifies and allows that bidder with the lower price to complete the schedule that was incomplete. In those circumstances, the losing bidder, which is higher priced, complains and says, well, the rules were not complied with because all the information needed to be completed. And the contracting authority retorts on Miss Sloane's case, it wouldn't have made a difference to the bid, to the outcome of the competition, because you, the losing bidder, had a much higher price than the winning bidder. The losing bidder could retort, well, we spent hours and days working on our pricing schedule to ensure that it was fully compliant, to make sure that we did everything that you asked for in respect of the rules of the competition. And that diverted time and resource away from other aspects of what we could have been doing to improve our bid. And had we known that in fact we didn't really need to do this, that you would waive the missing cell, you'd say it's not required to complete the cell, or you would have allowed us to correct it, we would have taken a different approach to how we bid. And on that basis, that may have changed the outcome of the competition. We don't accept in those circumstances that we are definitely the losing bidder. The point I make is that that hypothetical shows the problem with allowing amendments to bids after the bids have been submitted.
But you see, you've glided away from the issue in the case onto something else, and you're talking about amending a bid. This is talking about the issue here is about clarification, which is quite different.
My lord, I accept that we're talking about clarification, but the inevitability of clarification, we say, certainly in this case, would have been correction to Optima's pricing schedule. Because...
Well, hold on just 1 second, because I'm going to draw... I've already mentioned this authority to both of you, yes. And I'm just going to cite quote a sentence and then give you a chance to look it up. It's the case of Hersey, where there was a submission rejected as unworkable in practice because a contracting authority can't sensibly decide what the answer to a clarification question will be, or whether it would, quote, fundamentally alter the nature of the bid, if it hasn't asked the clarification question in the first place. And that, I'll just give you the reference for your note. That's paragraph 16 in Hersey.
Yes.
Before the applicable principles for clarification are then set out in paragraph 17.
Yes.
Now, they already, those principles, as at 2017, include the requirement for materiality. So I'm not really sure where your hypothetical example really takes you.
When you say they include materiality,
yeah, well, but perhaps let me give you the chance to turn it up. It's in paragraph 7. It's quoted in Mrs. Justice O'Farrell's judgment in Siemens, but Hersey's in the bundle.
Yes, I have it. I have it in front of me, Mike.
Okay, paragraph 17.
Yes.
There are 7 principles set out, and final sentence of subpara D. It's not necessary for the error to be clerical, whatever that might mean. But it must be simple, material, serious, and manifest.
My lord, we understand that's about the error.
Yes.
But it's not meaning, of course, Lord Justice Coulson, this is...
that was why I was struggling with your example, because it seemed you were going on to some hypothetical exchange between the winning bidder, the losing bidder, and how they might have expended their resources differently had they not known what was going to happen. This is about clarification of an error.
My lord, of course, I agree. My submission on this sentence is what's meant by simple, material, serious, or manifest is in respect of the nature of the error, not the effect it has on the outcome of the competition. This is not what's meant, in my respectful submission, by paragraph 17D. One is not considering the outcome of the competition. And and in my respectful submission, there is no support for that proposition. Ms. Sloan is putting forward essentially a new proposition that when one considers whether there's a duty to clarify, that the contracting authority should be looking at the outcome of the competition.
For my part, I didn't understand the proposition to be put in quite that way. Rather, I understood the proposition to be that when you're looking at the concept of equal treatment, you don't look at it for its own sake, but look at it in terms of its purpose. And its purpose is part of a process which is designed to ensure healthy and effective competition. That's how I understood the submission.
Yes, and we don't disagree with the submission, my lord, that its purpose is that. But you don't test whether there has been equal treatment by looking at what the outcome of the competition was.
Not the outcome of the competition, but you do need to test whether there has been equal treatment, don't you? You test what the meaning of that phrase is by reference to whether the unequal treatment or alleged unequal treatment is something which has prevented a healthy and fair competition or effective competition.
Yes, my lord, but it's hard. We say it's hard to do that by taking the facts of a specific case, in a sense. That's why the principle is at a higher level, a more general level, and I'll take your lordship to the relevant cases, which obviously restate the principle. But we say it cannot be tested by using this one case as an example and saying, look, the scores were incredibly narrow, ergo there is some form of discriminatory impact, or there would not be discriminatory impact if we were to solve this by a clarification question. That's not, we say, the correct way of looking at what equal treatment means. That's my submission. And in respect of materiality, just picking up on Lord Justice Fraser's point, we say that Hersey, my lord, is not authority for the proposition that materiality is relevant. And by materiality, I mean the outcome of competition is relevant when considering has a duty arisen on a contracting authority in a particular case to clarify or to waive. The second high-level point is to pick up on the exchange that Lord Justice Zacaroli had with my learned friend towards the close of her submissions, which was the reasoning in the Harrow case and the concept of a change to a bid. We say that is the correct approach. One has to look at whether there has been or would be a change to a bid in testing whether it would be in breach of the principle of equal treatment to clarify or to waive in a particular case. And taking a step back, my lords, we say that's in a sense obvious, because it is the definition of unequal treatment to allow a bidder to be permitted to change their bid. And by change their bid, I mean by reference to the substance, the contents of their bid, after a deadline. We say it's, with respect, obvious that that would be unequal treatment where one bid is permitted.
So Siemens is wrong, Tideland's wrong, Antwerp's is wrong.
My lord, no, because we say that, and we commend the reasoning of His Honour Judge Waxman in that case, that properly looked at.
Judge Waxman on that point's obiter, I think, but because that's another not completing the answers question, issue. But just you said that if there's a change to a bid, that's the definition of unequal treatment, to allow any change.
To allow, yes, my lord, to allow one bidder after.
That's what happened in, say, take Antwerp's as an example. The bid was changed.
Well, on one view, yes, but on one view, no, because the bid never said otherwise. That's the concept of an obvious error.
That's a philosophical position that won't be featuring, certainly speaking for myself, in my judgment in this case. It's quite clear that this court's going to have to provide practical guidance to where this goes. That's why I asked Miss Sloan about what is meant by a new bid.
Yes.
And she was very careful to say she thought that was a matter of fact and degree. But your submission, if this is right, is it isn't a matter of fact and degree. Anything that could give rise to a change is impermissible.
My lord, we don't go as far as saying anything that would give rise to a change.
The definition of unequal treatment is to allow any change.
Any change, my lord, to the substance of a bid.
Well, what does that mean?
Well, could I take your lordship to the Energy Solutions case, which my Lord Justice Fraser obviously gave judgment in, and there's a distinction drawn in that case between a change to form and a change to content.
Well, I understand that, but that you're making a different point. Any change to the substance of the bid. So, I mean, deal with it in your own time. Yes. I don't need an answer now. But the cases that I've just identified are cases where the substance of the bid changed. I mean, in Siemens, it was apparently worth hundreds of thousands of pounds. Might be difficult to say that wasn't substantive. In Tideland, they were allowed to bid, although they had not identified the correct date. In Antwerp, they changed the figures. So at some point, it doesn't necessarily have to be now, but I need to know what's between you on this. Miss Sloan's cautious response is a question of fact and degree, and I made the point to her, well, I've got to take into account things like certainty and not imposing too great a burden on a contracting authority, all of which I get. On the other hand, if it becomes draconian, if effectively you can't have clarification because it might give rise to a change, that instinctively simply doesn't sound right to me.
And we don't go as my lord, and I should be clear, we do not go as far as that, and I did not seek to give the impression that we do, my lord. Let me be clear. I was relying upon the Harrow case to make my point, but essentially we say they're two sides of the same coin, that being submission of a new tender and a change to the substance of the bid. of course, if this court feels that the better description or the better test is in substance a new tender, we don't disagree, my lord. We, of course, don't seek to argue otherwise. And that, we say, is sufficient for our purposes, my lord. Is this a new tender? That's the test. We simply say that a change to the substance is really saying the same thing. Your lordship may feel, of course, it's not, but we pray in aid of the Harrow case in order to make that point. But it's essentially that point, submission of a new tender. And we say that and we agree with Ms. Sloan, that is an issue of fact and degree. We don't disagree with that. We say that supports the respondent's case, in that the trial judge obviously had all the evidence before him, considered the matter carefully. None of the findings of fact are being appealed, and having considered all matters, reached the view that this would be, we say, reading his judgment, in substance a new tender.
Yeah.
And just in an effort to help, and then I'm going to shut up, I'm taking this from Hersey as well, because in paragraph 20, the judgment quotes the general definition of equal treatment, taken from Fabricon. I'll just give you a moment to get there.
Yes.
It's on page 710 of the bundle.
Yes, I'm there, my lord.
Yeah, have you got 710?
Yes.
You see against letter C,
Yes.
it's settled case law, the principle of equal treatment requires that comparable situations must not be treated differently, and different situations must not be treated in the same way. So if you've got two tenderers, you've got these cell issues, you would obviously be breaching equal treatment if you sought clarification from one and not from the other.
Yes.
But if you've only got one tenderer who's in that situation, I'd be grateful for some guidance as to how you say it would be a breach of equal treatment to seek clarification of that tenderer if the other one doesn't have the same problem.
My lord, you run into the same issue, which is if that if the completion of that cell is in essence a submission of a new tender,
all right,
you run up against the same issue. That's our point, my lord.
I understand.
Sorry, I need to press on this because I'm not following the distinction between a new tender or changing the bid, which you say are the same thing.
A change in the content or substance of the bid, yes.
And the most minor of corrections to amend an error or to put something there where the bid was incomplete, both of which things are expressly permitted by Regulation 56.4. Any such change or correction would be a change, wouldn't it?
Subject to the principle of equal treatment, my lord. So Regulation 56, of course, refers to the examples of errors or matters being incomplete, but subject to the...
Well, I understand that, but I think it's up to you, isn't it, to identify the nature of the changes, a correction or a filling in a blank,
yes,
that would fall on the wrong side of the line for being unequal treatment, or would fall on the right side of the line.
We say the law is clear on this, my lord, and we don't seek to go beyond it, which is that it falls on the wrong side where that would lead to the submission of a new tender.
But that's a question of fact. And yes. I don't understand how I'm looking at any particular case to determine whether what has now happened is the sort of change which means there's a new tender and one which there's not. How do I decide which is which?
Well, my lord, that's if I may have a think about that, but we would say that exercise, all the material issues and facts were before the trial judge to consider that exact issue, and that's a matter of fact and degree, and it will require. I mean, it will require particular examples. So take this particular case, of course, which we're concerned with. You have 4 prices which are in breach of the obligations in the ITT. Optima needed to, had it been compliant, or had it done this correctly, would have needed to place 4 prices within the schedule which were at or below the framework prices, framework maximum prices, I should say. The purpose of the competition, and this is significant, was for bidders to price competitively, and therefore to, where they could or chose to price below their framework maximums. And Optima's evidence, and Ms Sloan accepted in her submissions this morning, with respect to a number of those service lines, did price below the framework maximums. If Optima is then given an opportunity to put 4 new prices into its pricing schedule, which were not present anywhere else in the pricing schedule, are simply 4 new prices, we say that in essence is a new tender. It's a new pricing proposal.
However material.
However material, exactly, my lord, because a test is not materiality, precisely. And the example I was giving, but of course I'll put it in writing overnight and put this forward, is that where materiality is seen as an answer, poses problems, will pose problems in future cases, because issues will then arise as to, well, is it really material? And will a
Well, I think we've got enough on our plate deciding this case. I don't think an in terrorem as to what might happen in future cases. I agree about certainty,
yes,
and I welcome your submissions about certainty. But we have to be slightly careful that we don't try and reinvent the wheel.
Of course, my lord, and we say we're not seeking to reinvent the wheel. In fact, materiality, which is a test Ms Sloan impresses upon the court, is seeking to reinvent the wheel. And we say that there's a fundamental principled issue if that were the test that this court were to adopt. Because
you say materiality is irrelevant, because you say the outcome of the competition is irrelevant.
That's our first point, my lord, yes, but we say...
Well, those 2 points are linked, aren't they?
They are linked, my lord, but the second point we do emphasise, which is we say it would lead to all sorts of problems in terms of complaints and enforcing that test, if you were to have a test of materiality. And I'll set out the example so that it's clear, but we say that would lead to problems. So there's a principled approach as well as a legal approach, if I can put it that way.
Okay.
If I can then, having made those points, if I can then deal with some key factual points, which we say are important to consider. The first I've already made, but it's worth repeating, which is that it's not an issue that the purpose of holding a mini competition in this case was so that bidders could offer better prices than their framework maximum prices. And for your reference, I won't take the court to it, but it's the judgment at paragraph 7, which is tab 5 of the core bundle, page 48. Second, as your lordships will no doubt appreciate, Optima and all the other bidders were repeatedly told their prices could not exceed framework maximum prices. Again, for your reference, judgment at 14, paragraph 35, paragraphs 42, 45 and 46. See also paragraph 135. Third, and again, I've made this point, but it bears repeating, for some service lines, Optima did bid well below the framework maximums. And again, the judgment has that at 190, which is at page 191, tab 5 of the core bundle. Fourth, and we say this is relevant to this issue of obviousness of an error. The Department for Work and Pensions had no way of knowing what prices Optima had in fact intended to bid for the service lines. And again, that's a finding of fact. See paragraphs 190 to 192 of the judgment. That's at page 97 of tab 5. nor we say, was there any mechanism in the invitation to tender, and this must logically follow from my learned friend submissions on ground 1, that the ITT allowed DWP to discount the prices, i.e. reduce the prices in excess of the framework maximum prices down to the framework maximum prices or any other price. See paragraph 144 of the judgment, page 87 of that tab.
So that was paragraph 144.
144, my lord.
And the previous paragraph, I got confused between the paragraph number and the page number. It's entirely my fault. You said that DWP didn't know what prices Optima intended to bid, and you referred to paragraph numbers there.
190 to 192, and that's at page 97, my lord.
190 to 192. Thank you very much.
Fifth, and obviously this no doubt will be developed in submission, permitting Optima to clarify its pricing would have amounted to a change to the substance of the bid. And that's at 196, that finding. That's a finding of fact. And that's at page 98, my lord.
Well, that isn't a finding of fact. That's a matter for us. That's the critical point.
Well, my lord...
is it the substance of the bid or not?
Well, my lord, we would say...
That's squarely an issue in the grounds of appeal.
I accept it's squarely an issue, whether it's a matter of law or a matter of fact. We say it was quintessentially a matter for the judge hearing all the evidence and considering the arguments in the court below to decide on that evidence whether what would have needed to happen to Optima's pricing schedule, and by that I mean that 4 new prices go into those service lines to replace the non-compliant prices, was a substantive change to the pricing schedule.
You're probably, or you might actually be putting it slightly the wrong way around. But the issue for us is, should they be permitted to clarify the bid? And that's the reason the judge found that they ought not to be.
Yes, yes, it is the reason, my lord. But we say that's.
I know you support that reason.
Yes, but we also say it's a test, in a sense, of when there will be a duty to clarify, or when that duty does not arise. And we say, and this is the point at the outset, if there is in fact a change in substance, or in essence a new tender that would be submitted, then clarification is not possible. In other words, DWP cannot exercise its discretion, because to do so would breach the principle of equal treatment.
That would be true whenever the tender, as corrected, contained a figure, a number, a letter, a word that wasn't there before.
That turns on, my lord, whether, and we say these are two sides of the same coin, whether there is ambiguity or obvious error. And we do submit there's a reason why the concept of a change to the bid has come hand in hand with the idea of an obvious error or an ambiguity. And the reason for that is that where you have an error, where the authority can see that's an error, and the bidder must have intended to put this in instead. They must have been intending to say this. By allowing a correction in those circumstances would not amount to either change the substance of the bid or put another way, allowing the bidder to submit a new tender, because the authority knows that that is what the bidder always was submitting, was always intending to submit.
So error only means where, one, you can see that what was put there wasn't intended, and two, you can tell from the document as a whole what was intended.
Yes, the document as a whole and the surrounding circumstances, we would say.
But not including asking them.
No, because the difficulty there, my lord, is if it's not obvious in the sense that I've just outlined, by asking them, that opens up the possibility that they may tell you, oh, this is what we intended to put here. So test it. It's a price to be inserted. And it could be anywhere from, I don't know, 1 to 1,000. The authority has no idea. It knows there's an error there, but it has no idea what the price should be. It opens up the possibility of a bidder putting in a price it never intended to put in the first place. Once it's given that opportunity, it looks at the situation and says, okay, you know what, we've had to think about it. We'll put in this much lower price now. That's the difficulty. And that's the problem that...
So they can only seek to ask a question to which they already know the answer.
Or highly suspect that the answer...
Well, you said they had to be able to... They had to know that the authority knows what it was that the bidder intended to include. So they are asking a question to which they know the answer.
Yes.
That must follow.
Yes, my lord. And we say that there's nothing odd in that proposition. My learned friend has said in her skeleton, well, that would mean there's no need to ask the clarification at all. That's the submission that's put forward. That's not right, my lord, because the bid says something else at the point it's been received. And it needs to be, the process needs to be brought to an end. A decision needs to be made as to who will be awarded the contract. The clarification is necessary to regularise the bidder's situation. That's the purpose, my lord. But it's not the purpose. Sorry,
no, do finish.
I was just going to say, it's not, the purpose is not and should not be to give a bidder a second bite of the cherry, and that's what the obvious error ambiguity test on the one hand, coupled with the idea of is it really a new tender, is it a change to the substance of the bid on the other, is intending to guard against. Because of course, if that happens, if you give the bidder a second bite of the cherry, that is a definition of unequal treatment.
Well, my difficulty with that submission is that it comes pretty close to, if not outright, redrafting of Regulation 56.4.
If I have a look, have a look at Regulation.
No, by all means.
Of course. So, of course, your lordship has the wording well in mind.
Because that expressly has a proviso that those requests have to comply with the principles of equal treatment. So let's put that to one side. If you look at what is permitted by the regulation,
yes,
contracting authorities are permitted to request supplementation, clarification, or completion, aren't they?
yes, but compliant with the principle of equal treatment.
Yes, but what you're effectively saying is if it's going to lead to any new information that they don't have already, it will fail the principle of equal treatment.
Well, there's a difference, my lord, between information, if you like, a form that is missing, and a situation where you've got existing content which you're seeking to change. And that reminds me, my lord, I'm grateful to your lordship, that I should take your lordship, as I mentioned it earlier, it's a good time to take your lordship to it, your decision in Energy Solutions, because I think your lordship alighted upon this point about this distinction. And so we're in the authorities.
It was my fault. Mr. Zacaroli. You were about to go to Energy Solutions, and I asked you a question.
Not at all, Mike.
And so it was entirely my fault.
It's
We should now turn up my lord's doorstop.
it's a tab
You might have
19.
asked the question to put off that dreadful moment.
It's tab 19.
Yeah.
And it begins at 360. You'll be glad to know that we're not going to stay at 360. If I can take your lordships forward, please, to my Lord Justice Fraser's reasoning, which begins with the judgment at 849, page 653. This is in relation to the threshold issue that arose in this case. And if we then go forward, please, to 870, which is at page 659. You see at the bottom of 870, this is not the same as reaching a below threshold evaluation or fail and then deciding whether to exercise a discretion to avoid disqualification and hence increase the score for that reason. The answer to the complaint 871 of disproportionality by the NDA is a simple one. And there's reference there to those cases. And then if I can take your lordships forward at 872, further, Commission and Ireland make it clear that rules cannot be changed after the competition has started. The rationale for this is that this may favour certain tenderers. And then my Lord Justice Fraser considers the Tideland case at 877, page 661, and then Leadbitter. And then see this at 883 and 884, which is consideration of Professor Arrowsmith's views on this issue. And at 884, there's consideration of what was said in the third edition, which I think is the most recent edition. A requirement whether substantive or procedural would be considered fundamental. There's the notion of a fundamental requirement. If the need to comply with it might have deterred other tenderers, or where waiving the requirement would give rise to significant risk of unequal treatment. This is rejected by my Lord Justice Fraser, 885. Further, the test is not, nor in my judgment should it be, that waiver of a requirement is permissible unless it gives rise to a significant risk of unequal treatment. Leadbitter demonstrates this in my view.
With respect, it's not your fault because it's a very long judgment. A better place to look is at paragraph 256, because the passages that you're reading are related to the waiver of a requirement that was stated to require mandatory disqualification of a bidder. Clarification is probably best looked at from 256, and this is the passage which Mrs. Justice O'Farrell quotes in Siemens just after she's quoted the passages from paragraph 17 of Hersey that I took you to a few moments ago.
Yes, my Lord, I see that, but of course, if I can finish this.
No, of course.
And the only reason why, my Lord, is my learned friend is in her case, she, with respect, conflates waiver with clarification and with correction. So if you look at the grounds 2 to 4, all are put in issue. And so I am addressing this in the context of waiver, but we say it's a general principle. If your Lordship turns over to page 664, 889, matters within this is the second half of the paragraph, within the control of the tenderer, particularly those that go to what must have been a tenderer's decision as to the substantive content of the tender submission, will really, in my judgment, be sufficiently exceptional to justify an application of the principle to excuse non-compliance. Tideland can be explained as not going to substantive content. So I'm seeking to return here to the point that my Lord Justice Zacaroli raised about, I think it was Lord Justice Zacaroli, in terms of content. And this is said at 890, and this is the submission made, which is rejected by NDA, that excluding a tenderer for failures that are venal or trivial, or for failures that had no real impact, would be disproportionate. This may be using different words to present Professor Arrowsmith's views. In my judgment, the correct approach is to characterise the failure firstly as one of either form or content. If form, then there's a second step. If the failure relates to content, in my judgment, the second step would not fall to be considered at all. The second step would then be to consider the scope and extent of the failure. If merely trivial, then the authority could potentially waive the failure, as long as doing so would not breach the obligations of transparency and equal treatment. Further, such waiver should only be permissible in the most exceptional of cases. It is important to differentiate between cases where the rules of the competition entitle the authority to waive non-compliance and those that do not. Those authorities engaged in competitions where the rules specifically do not permit this will really be entitled to act contrary to those rules, of course, although of course the rules will differ in case to case. So just pausing there, I do seek to pray in aid of my Lord Justice Fraser's reasoning here, which I commend to the court, of course, that there is a distinction between form and content. And to answer the question I think was posed by my Lord Justice Coulson about, well, a clarification will be asked, is it your submission, Mr. Supervisor? The clarification will be asked where you know the answer. Well, we say in the context of form, then we say when it comes to form, there is scope to permit correction, exceptionally, even then exceptionally. But when it comes to substance of a bid, the contents of a bid, we say to allow a bidder to change the substance of their bid after it has been given an equal opportunity to put forward its submission in the competition would be a breach of equal treatment.
So that would require a rewriting of Regulation 56 forward, because you'd be writing it as saying that the power to seek clarification only exists where the error is one of form, not content. Or not one of
my Lord, we say that's encompassed by the principle of equal treatment. That we say, yes, that it could be rewritten, my Lord, but it's unnecessary because that's encompassed and encapsulated, perhaps is the best way of putting it, by the requirement to comply with the principle of equal treatment.
And you say this because what my Lord Justice Fraser was talking about there, I say with great trepidation, was waiving a mandatory requirement.
Yes.
Not a power, as we have in this case, to seek clarification.
Yes,
and you say the same applies, do you?
I say the concept of form and content is one that applies to both waiver and clarification, and that's I say is consistent with the authority. So in my Lord Justice Coulson's judgment in Hersey and the concept of submission of a new tender, what can that mean other than the content of the tender? That's the submission of a new tender. You're looking at content, looking at substance. That's not the same as form. So the distinction is a useful one in my submission. And we say it was a matter for Mr. Justice Freedman at trial to looking at the facts to consider whether this would be whether clarification would lead to a change to the substance, to the contents of the bid. And we say, in a sense, the test is, your Lordship, my Lord Justice Zacaroli asked about, well, what is the test? How does one judge whether there's been a change to the substance of the bid or whether there's a submission of a new tender? I'm not sure whether this court can provide a principle that will apply across all cases, because as I think my learned friend accepted, it is a matter of fact and degree, and that will vary from case to case. In a sense, and I don't put this, excuse the common language, but in a sense it's the elephant in the room test. You know it when you see it. If you have a pricing submission which has a series of prices, and then it changes and has other prices, we say that that is the submission of a new pricing schedule.
Well, I think you have just said that it turns on whether it's an amendment of form or substance.
Yes, and a change to a pricing submission, my lord, in a procurement, where pricing will ultimately be, in most procurements, at the heart of the content of the bid, will inevitably be a change to the content of the bid. If a tenderer puts forward one pricing submission and then says, actually, no, this is what we meant to say in our pricing submission, here you go. My respectful submission, that would be a new tender.
Yeah, so I may be putting words in your mouth. Are you saying that the dividing line is the same as that between form and content? Or is that just one example of something which you can say is within or outside the rule? Is there more to it than that?
My lord, I'll have a think about that. My submission is a useful way of approaching it is form and content when one looks at whether there is a new tender. So those were my introductory points. I now propose, with the court's permission, to address the grounds more specifically. I propose to take grounds 2 to 6 first, as those are the ones that my learned friend finished on, and I thought that would be helpful to the court. If the court wishes me to take ground 1 first,
I would be quite... I think I don't want to take you out of your course. I think bound to say it would help me, I think, if you dealt with ground 1 first, because ground 1 leaks through quite a lot else, so it seems to me, and I'd like to hear your submissions on ground 1 and then hear your submissions on what its relevance is to the depending on who's right or wrong on ground 1. So,
well, my lord, of course, I'm in your lordship. I'll do what your lordship asked me to do. Could I just address your lordship on this issue of whether it does leak through, as your lordship puts it?
Well, it leaks through in the judgment because he refers to it repeatedly in the latter part of the judgment. Before we deal with the effect, why don't we deal with the point? I think that's why I'm asking you to deal with ground 1 first.
So be it, my lord. So ground 1, obviously your lordships have seen this clause now repeatedly, and I won't take you back to read it at the moment. It's common ground between my learned friend and I that the correct approach to assessing whether procurement documents are sufficiently clear is obviously the R-Wind test as set out in Healthcare at Home.
I'm looking forward to a case, and it doesn't arise here happily, but I'm looking forward to a case where there's a difference between the approach of an R-Wind tenderer and the ordinary rules of construction as helpfully set out in all those recent cases by the Supreme Court. I'm sure one day there will be a case where the answer applying one lot of rules is A and the answer applying a lot of other rules is B, but I don't think that arises here.
Well, my lord, could I answer that by taking your lordship back to some passages in Healthcare at Home, because we do say that it is important for the court to bear in mind Mr. Justice Freedman's findings, and that we say that the proper approach, with the greatest of respect to this court, is not to approach the issue de novo, if you like, and simply to interpret the clause for yourselves, but to do so in the context, of course, of the findings below. And let me make good that point if I can. So we're obviously back in the first bundle, authorities bundle, at tab 16, page 285.
Yeah.
So my learned friend, of course, took you to paragraphs 5 and 8. Could I take you, please, I'm not sure if my learned friend did so, but just take you to paragraph 14, which is at page 290. And this is said, the rationale of the standard of the R-Win tender is thus to determine whether the invitation to tender is sufficiently clear to enable tenderers to interpret it in the same way, so ensuring equality of treatment. The application of the standard involves the making of a factual assessment by the National Court, taking account of all the circumstances of the particular case. So we say, whilst the standard itself is a matter of law, and there's no issue between us in this case that Mr. Justice Freedman correctly directed himself as to the applicable test, its application requires a factual assessment in order for the judge to make factual findings so as to lead him or her to decide whether the documents are sufficiently clear to permit of uniform interpretation by all R-Win tenders.
You'll also want to look at 27, I think.
My lord, that was exactly the next paragraph I was intending to take your lordship to. And then 27 at page 293. The court has to be able to put itself into the position of the R-Win tenderer, and evidence may be necessary for that purpose, for example, so as to understand any technical terms and the context in which the documents had to be construed. And we do place some importance on that one, or the context, as I'll take your lordships onto, is important in this case. And picking up on my Lord Justice Coulson's point a moment ago, although as counsel for the appellants emphasised the question is not one of contractual interpretation, the issue is not what the invitation to tender meant, but whether its meaning would be clear to any R-Win tenderer. It is equally suitable for objective determination.
Yeah.
And then could I ask your lordships to have a look, please, at paragraphs 29. Perhaps the court can read that to itself. My lords, we do rely upon that passage to respectfully submit to the court that the exercise for your lordships in this appeal, with respect, should not be to approach the interpretation of clause 2.2 afresh, but in the first instance to consider whether first, that the judge below directed himself correctly on the law on this issue, and then secondly, having directed himself correctly, whether the judge made errors which are susceptible to appeal to this court. Is there an error of principle which Mr. Justice Freedman made. Now we say, my lord, and we say in that respect, my lord, the test that's being referred to in paragraph 29 of Healthcare at Home is similar to my Lord Justice Coulson's test explained in the Farrow and Rylett case, which is in the authorities, volume 1, it's right at the back of volume 1, I hope it's tab 23, page 769, the judgment begins. Your Lordship will recall this was a dispute.
Tab which, sorry?
Tab 23, page 769.
That's
Back of
2.
Back of bundle 2.
I'm so sorry, my lords.
All right.
And your Lordship will recall, your Lord Justice Coulson will recall, this was a dispute, a property dispute, and the meaning of an oral agreement, and in considering the appeal, your Lordship said this, and we can see it at page 777, paragraph 22, beginning at paragraphs 22 onwards, and perhaps I can just ask your Lordships to just look at paragraphs 22.
I mean, that's
just a classic statement.
with respect to me, trite stuff about findings of fact.
Indeed, but we pray in aid of it, my lord, and we seek to rely upon it.
I understand.
And we say that it does have, in the light of paragraph 29 of Healthcare at Home, it does have relevance to how your Lordship should approach the ground 1 and clause 2.2 on this appeal.
Yeah.
It may matter to what extent the judge below was relying on evidence and what evidence the judge is relying on to reach the conclusion. So I noticed that in the case you just took us to, which was, I forgot the name already, Healthcare at Home, was it?
Healthcare
Yes.
at Home, yes.
There was a reference to the evidence as to how it was received by people, I think.
Yes.
In this case, what evidence was there other than the documents themselves?
Well, there was evidence, my lord. So if I can take your Lordship to the findings of fact made by Mr. Justice Freedman. So we're into the core bundle at tab 5, of course. Begins at page 42. And could I take your Lordships first to paragraph 141, which is at page 86. And I think you've looked at this already this morning, but the judge there is making findings linked to paragraph 130 of the
Those are the submissions.
Yes.
Yeah.
So he's the judge below is recording submissions and then agreeing with those submissions.
Yes.
And those are findings, my lord, we say, of facts. So,
sorry, what's a finding of fact?
well, the context of the other references to the requirement not to exceed framework maximum prices and need to comply with the rules of the ITT, failing which was a right to exceed bidder. And that's at 130 Roman 1. And then at Roman 3, there was no suggestion in the ITT that DWP would adjust the bidder's pricing for the relevant individual
You
lines.
get that from the ITT, that's not a finding of fact. These are all apparent from the documents. It's a question of whether there's a particular finding of fact that I quite accept that these points may go to. I mean, I'm bad to say, but you can point out my error. In the passages between 132 and 142, which are effectively the core of this part of it, I didn't really see any findings of fact. It's all talking about the documents, and the judge's, perfectly clear explanation of what he draws from the documents. And as you pointed out, his agreement with your submissions at 130, which again are references back to the ITT.
Well, my lord, if one looks at 142, we say that that's a recognition of the facts of this case, namely that it was made clear to the bidders repeatedly that their pricing had to be below the framework maximums.
I don't think that's an issue.
My lord, not, but that's a fact. That's so be it.
We get that from the ITT. You'd have had to have been a particularly dim R-wind tenderer in this case not to know that they didn't want prices above the maximum.
My lord, yes, but the context, of course, is, and that is a factual finding, that it was made repeatedly. So you had repeated pricing schedules.
Well, again, I don't think that's in dispute.
No, but we say that that's irrelevant. We say that's relevant to the context, my lord.
Okay.
That we rely upon in terms of the context when one comes to interpret clause 2.2. We're then concerned with whether there's an error of principle, the judge having correctly directed himself on the R-Win test and the test set out in Healthcare at Home. And a number of points are made in my learned friend's skeleton in this respect, and if I can turn that up, please. It's in the core bundle at tab 12, page 187. And the points of principle, or the errors alleged, begin at paragraph 42, which is at big page 203, internal page 17 of the skeleton. And here my learned friend seeks to identify an error of principle, or an error. Mm-hmm. And if I can make my submissions in respect of these, in respect of point A, we say that that's simply a disagreement with the judge's conclusion, Judge Below's conclusion, at 42A of the skeleton. At B, it said that the judge failed to consider the procurement documentation as a whole. But we say that's incorrect, my lord, if one looks at the judgment at paragraphs 138 and 144. And it may be helpful for your lordships to keep one hand on the skeleton here and go back to the judgment. 138 is at page 85. Mm-hmm. And then 144, my lord, as well, at page 87. So there's consideration of the procurement documentation more generally. 144, my lord.
I took this point to be the point that is being made here is that there were numerous parts of the ITT which talked about disqualification or exclusion, and clause 2.2 didn't. And I took this point to mean that the judge hasn't referred to the other parts where exclusion was referred to, some of which we looked at this morning.
My lord, we would say the judge below was alive to that point, because your lordship, if your lordship has a look at paragraph 124 of the judgment, which is at page 82.
Yes.
There's obviously the reference to the documentation did not state the failure to meet the requirement would lead to disqualification.
Yes.
There's a reference there to the reference to reserving the right to exclude, so the judge is looking at the different wording.
Yeah.
And then if one has a look at 136, judge clearly had in mind this point. The judge says that it is correct that there were certain requirements where failure to follow the same was disqualification, e.g. various questions in the key participation requirements in questionnaire 1 of the attachment 2, consequence of not answering, etc. So the argument put by my learned friend that the judge failed to consider the procurement documentation as a whole, well, my respectful submission, the judge clearly has.
Yeah, okay.
But going back to 144,
Well,
the first sentence is exactly what one's supposed to do, in the sense of you're looking at or the judge is looking at the wording in the ITT.
yes.
The final sentence is unobjectionable, but the two sentences in the middle about what the evidence do or don't show, isn't that exactly what Lord Reed in Healthcare at Home said you don't do? I mean, he in a sense, if he is wrong there, he's probably wrong because of Optima rather than because of
My lord, yes,
the
that's
department. Because at the end of 121, Optima have submitted to him that he should listen to evidence,
exactly
the views of a particular tenderer.
precisely, my lord, and exactly your lordship has the point, because at 144 he's in fact recording, I believe, the point being put upon him by Ms. Sloan in Optima's evidence to say, oh, in the past there had been unilateral reduction and this was relevant. And of course we've seen that, seen some suggestion of that by Miss Newey's evidence. You were taken to that this morning, paragraphs 33 to 35. This was part of Optima's case, the evidence before the court.
I do understand that,
yes.
but Healthcare at Home says that's not how you go about deciding what a tender would mean to an Arwin tenderer. You look at the terms.
My lord, I accept that, but I don't see here that in my submission that Mr. Justice Freedman is relying upon this or taking into account. He's just recognising that that's the submission. There was an attempt made by Optima to make this point, and he doesn't rely upon it to reach his conclusion on the correct interpretation of clause 2.2. That's my submission as to how you read, in my respectful submission, paragraph 144. He's not fallen into error, my lord, because in fact
He's doing it on the document.
Yes,
which is what we've seen Lord Reed says you ought to do, unless there's a technical term you need evidence for. For example, this morning one of the cases we looked at had a debate about outputs.
Yes,
there was evidence in that case as to what in that industry outputs should or could be interpreted to mean.
My lord,
in the absence of a technical term, you just look at the words, don't you?
Well, my lord, of course, the focus is on the words of the relevant provision. But Healthcare at Home, in my submission, does not go as far as excluding relevant factual context. And it may be relevant, certainly it was Optima's case, but it may be relevant factual context is if DWP or another contracting authority had done this in the past, had discounted prices by reducing them in a particular way or reducing prices. We say that it's open to the judge to consider that as relevant factual context. It may not ultimately be determinative of how the Arwin tenderer would have understood the relevant provision, but it is relevant factual context. But in any event, the evidence is made out.
That's enough relevant factual context.
My lord,
you were going through
I was, my lord, yes.
the
So
items in paragraph
yes, paragraph
42.
42, yes, my lord. Page
yeah, so you dealt with A and B.
yes.
C.
Now we say, my lord, that submission, with respect by my learned friend, is incorrect, in that there is nothing erroneous about this reasoning. It is logically independent to ground 2. Optima does not dispute that the ITT did not say what level prices should have been reduced to, if they were to be reduced. And the judge, we say, was entitled to take into account that fact in his assessment of how the Arwin tenderer would have understood clause 2.2.
Okay.
And then in respect of the final point made by my learned friend, which is the absurdity, draconian effect point, it said that the judge failed to pay regard. Well, the judge did have it in mind because he acknowledged the submission at 125 of the judgment, page 83. And see also, my lords, 141 at page 86. So, my lords, we say that the starting point is that my learned friend has not identified an error of principle which should lead this court to interfere with the judge's conclusion in respect of clause 2.2. If I'm wrong about that, then I come on to make my submissions on the wording. If your lordships seek to consider the interpretation afresh.
Yeah.
And of course we accept, my lord, that looking at the clause face on, the word discount bears two meanings, could have two different meanings. Mm-hmm. Disqualify or reduce the price. But we say that when one considers the context, that the Arwin tenderer would only have known that it meant disqualify. And my submissions on this are as follows. Of course, we submit that one has to look at all of the relevant context and documents.
Yeah, you keep saying that as a generality. I'm waiting for some specific bit of context that would lead to that submission being correct.
Well, my lord, we rely upon the same documents that my learned friend did. Namely, we had the framework schedule, so we can have a look at those in the supplementary bundle.
But make the submission.
Of course, my lord. Yes.
What is the context?
So the context
that makes this means disqualified.
Well, the framework schedule made clear, Schedule 3. It's just for your reference, the supplementary bundle, page 29, tab 2.
Yeah.
That there would be maximum framework prices.
Yeah.
The pricing instructions repeatedly made clear that the individual service lines in the bidder's bid could not be in excess of the framework maximum price.
Yeah.
So that, we say, is the context. We then look at the actual wording, and it would be helpful, my lords, to go to that, so your lordships have it. And we find that in the core bundle at it's at tab 10, page 159. And at page 161 we have clause 2.2.
Yeah.
We say that the maximum contract value is simply a reference to the function of the prices which the bidders submitted when they went onto the framework. So that is referring to the totality, if you like, of their prices when they came onto the framework. And we consider that the first sentence is simply setting the scene for the next part of the sentence, which is the bit beginning any bids. And in my submission, it's clear that any bids is the subject of the clause. So, based on the ordinary meaning of the language, the action applied, i.e. the action of discounting, to the level of the bid, not the level of the service line. if I'm right about that, my lord, then it follows that you cannot reduce, well, my submission, the R1 tenderer wouldn't have understood this to be a reference to reducing a bid, and therefore discount bore another meaning. And we say the only alternative meaning is to disqualify. Disqualification operates at the level of the bid, whereas the prices being offered in the service line operates at that level, the service line level.
But doesn't that omit the words that we're looking at to see what an R-win tenderer would think? Because it's not any bids, is it? It's any bids for any service line.
Yes, but
your skeleton talked about any bids, and I was a bit surprised, and so I went back to the words. And it's not any bids, it's any bids for any service line will be discounted. In other words, assume you're right, and discounted means disqualified or excluded. What is being excluded, so it would appear from the words, is any bids for any service line. So the 3 or arguably 4 that we're talking about.
Well, my lord,
which is not a point that the judge addresses at all.
Well, my lord, we would say, in respect of that particular point, that it makes no sense, and the R-win tenderer would have understood this, to exclude service lines. Because the R-win tenderer...
Why? Because if they're above the maximum price... I mean, I'm not suggesting... I mean, I'm assuming, for the purpose of this point, that you're right about excluded or disqualified. But that's just for the purposes of this point. Why? You've been told you mustn't put in a price above the framework, maximum price. You do. So that bid is discounted, disqualified, you say.
On your lordship's interpretation, testing it through, it would mean the removal of OH 58, 229, 230, etc.
Yeah.
If that were to occur, at the point of evaluation, the evaluation can't take place because you have...
There's nothing to evaluate.
Well, you've got bids, yes, but how does one do the
Which
comparison?
might then suggest that it means reduced.
Well, in my submission, it would suggest, my lords, that it would mean to remove the bid.
But it's not the bid. It's any bids for any service line. It's heavily, heavily qualified. Any bids for any service line. This is the problem, and you can think about it overnight because I think it's potentially important. It's not a point that the judge addresses, but it's not, as per your skeleton, any bids, close quotes. It's any bids for any service line. And that does seem to me, potentially at any rate, to make a difference.
Well, my lord, and I appreciate, of course, that the word is for, and it's not the word I'm now going to suggest, which is with. But if you were to read this...
Any words with what, sorry?
With. So if we were to replace the for with with.
With, where's for, sorry?
Any bids for any service line, my lord. Any bids with any service line submitted to the framework being historically these service lines were submitted to the framework, just recognising the fact that those are the service lines we're talking about, by invited bidders in excess of this, the framework, we say, will be discounted. Now, I appreciate, of course, my lord, I appreciate that's changing the word for with, but
Well, you've still got the first any bids issue. I mean, I'm just going to restrict myself to one observation in grammatical terms because I can be extremely pedantic about this. In this sentence, any is used as what's called a determiner, and as a determiner, it has a weak form and a strong form. And in the weak form, it's used in conjunction with indefinite quantities. So I'm sure that's something you want to look at overnight. But any bids for any service lines means it applies to the indeterminate quantities of how many bids or service lines there are. For it to mean the tender or the bid. It would have to be the whole bid, wouldn't it? Or the tender, rather than any bids plural.
Well, my lord, we would say any bids is referring to the plural of the tenders.
Understood.
Unless there's something that and it may be something you want to finish, by all means do, but if not, we can pick it up at that point tomorrow, if that's convenient to you.
Could I just make this one further submission in respect of this particular clause? We do rely upon the fact that the Arwin tenderer would have would have understood that its bid needed to be capable of being contractualised. And that flows together with the point on Schedule 3 and not exceeding maximum framework pricing without having service lines, each of which were below the maximum. We say the tenderer would have understood that there could be no easy contractualisation with DWP, and we say again that's a relevant consideration when seeking to interpret clause 2.2.
Okay, well, you've just about finished on ground one, have you?
Yes, I'll have a think overnight, my lord, if I may.
Yeah, okay, well, and obviously the point that will arise also in the morning is the question of what you say if you're right on ground one and what you say if you're wrong about ground one.
Well, can I just address that quickly now, my lord, so you have it
all right
in your mind? Our case on ground one is that if we're right about ground one, that's the end of the appeal, on the basis that there was a mandatory exclusion.
And that would have been the end of the case before Judge Freedman, Mr. Justice Freedman.
My lord, yes. Although I say that, my lord, but Mr. Justice Freedman had to consider, and this is relevant to ground 5, the argument put forward by Optima that it wasn't the end of the matter because there was a residual discretion. That's the.
But he wouldn't have had to have considered the stuff that forms the majority of the judgment, namely the duty, the alleged duty to seek clarification.
Yes. Yes.
That wouldn't have arisen.
Agreed, my lord. And my reading of my submission on the reading of Mr. Justice Freedman's judgment in that respect is that's in the context of the discretion. Those findings are by the judge are in relation. He's saying if there's no mandatory exclusion and there was a discretion to exclude.
But there isn't, on your case, there isn't a discretion.
A discretion, my lord, in the sense that...
as you've said, that's the end of it. If there's a mandatory exclusion clause, that's the end of it.
Yes, but...
So that would have been the end of it at first instance.
Yes, but of course the judge considered the alternative arguments, and the alternative we put forward...
Well, I understand that, but that's only if you were wrong on ground one.
Yes. If we were wrong...
But he doesn't say that.
Well, my lord, we say with respect, we say it's clear from the judgment that...
So all of the judgment is obiter except for the part on ground one.
My lord, I'll have a think about that, but I don't...
I mean, that must follow if ground one is the end of it. I mean, it goes back to the point I made earlier that I have to say with great respect, it wasn't made clear for the judge, particularly as he had to do this quickly, and did do it quickly, and it was clearly a large amount of work. It wasn't clear to him, I think, how these issues fitted together. At all events, you say if you're if you're right about ground one, then that's the end of the appeal, and you said that would also be the end of the case below.
Yes.
And if you're wrong,
if we're wrong, my lord, we say that we're then into the area of should the discretion have become a duty.
Yeah,
And
understand that.
yes, and we say that, and you'll have my submissions on that in the course of tomorrow.
And that's grounds 2, 3, 4, and 6.
Yes.
It's not ground 5 because ground 5 arises as an alternative way round the mandatory exclusion, if that's what it was.
Exactly, my lord. That's why the judge considered it, and we say he was right to consider it because it was the case being put forward by Optima, and he made his findings for that reason. And we say he properly made those findings. I hope that's clear, my lord, in terms of how we.
Well, it's clear.
Yes.
Your explanation is clear. As I say, I said it to Mr. Sloan, so I'll say it to you. Let the judge work out what the questions are, because it's usually much better in terms of working out where you go, if I'm right about that, if I'm wrong about that. All right, now, we need to rise no later than 1 tomorrow. You seem to be reasonably on track because you've just about down ground 1, but we can't sit beyond 1, so are you comfortable, the two of you, that 2.5 hours is sufficient?
I think that should be fine, my lord.
I think we'll have trampled the ground pretty heavily.
Yes.
In another 2.5 hours.
Yes, I do wish to take your lordship back to the cases.
Well, I understand that.
In respect of equal.
But
and so forth.
I'm just saying you'll need to cut your cloth.
Of course.
I wouldn't be. We need to allow Miss Sloan some time to reply, but not extensive. So I would have thought certainly not more than about 20 minutes.
Could I reserve position on that? So I've heard what my.
Well, you'll have to.
Tomorrow.
The two of you will have to come up with a timetable that means that we finish by 1.
Yes, but I hear the indication from the court. Thank you.
Thank you very much. 2 o'clock. No, 10:30.